All right, good morning, everybody. My name is Judge Kim Teresa Malika. You are in first appearance court. Today you're going to be informed of the charges and we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have the right to remain silent. Anything you say or do can and will be used against you. You also have the right to an attorney. If you can't afford an attorney, the court will appoint the public defender. If you have a private attorney, when you step up to the podium, please let me know. Or you can let Mr. Romero, I believe it is, at the main jail today. Who's at the main jail? Mr. Romero. Hi, good morning. All right, and we have Mr. Romero at the main jail, and we have Mr. Reedy from the public defender's office to my right. We also have Mr. Shate that's here, that's going to be handling any municipal ordinances for certain cities, and I guess Mr. McLaurin's for the city of Fort Lauderdale will be here shortly. So, if you do resolve your case today, and that's only for limited cases, some misdemeanors, no felony cases. If you do resolve your case today, I want you to know there's the potential that if you don't pay your court costs, I have to impose minimum court costs for municipal ordinances. It's $78. For misdemeanor cases, it's $293. And if you don't pay them, I'll give you 4 to 6 months to pay. You can just tell me when you step up to the podium, and I will let you know. If you don't pay them within the 4 to 6 months, then you have the you have the, one moment. The court costs within 4 to 6 months, then your driver's license may be suspended. And you also have a $25 late fee. So we're going to begin with a couple cases at a turn. If you're ready, Mr. Shate, or Mr. Shate's on the phone. No, we'll just take a couple in between. Let's call Mia Juan Alfred Davis, please.
Come on up here. She's here.
We'll take yours right after this. I thought you were on the phone.
She is approaching, Judge. Come on up here.
Okay, Ms. Alfred Davis, you have an out-of-state hold for a felony for insurance fraud out of the state of Texas. You have a no bond hold. The court does find probable cause. We'll see you in extradition court Tuesday or Thursday at 1 p.m. Thank you. All right, next one is Horace Fore, F-O-R-E.
Mr. Reedy spoke to Mr. Fore, and he would like to resolve the matter.
Okay. Okay, Mr. Fore, good morning, sir. How are you? Horace Fore?
Yes, ma'am.
Hello, good morning. How are you, sir?
Well, it'd be better if I was at the job, but hey,
I understand. All right,
Yeah.
Mr. Fore, you have 2 municipal ordinances from 2003, as a matter of fact, for urinating in a public building and carrying an open container. It's a total of $250. Bond, if you'd like to resolve your case today, we can resolve it. Or
Yes,
if you
ma'am.
want to, I will ROR you if you'd like, if you can't afford the $250 bond, and you can come back to court and fight it. What would you like to do, sir?
I'd like to resolve it, ma'am.
Okay.
So I can get back to work.
All right, withhold and court costs on each one, Mr.
Yes, sir, that's fine.
Shate? Yeah, it's 2 different case numbers, 2280 and 2279. All right, sir, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right, your name is Horace Fore, H-O-R-A-C-E-F-O-R-E, sir?
Yes, ma'am.
All right, it's my understanding you want to waive your right to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am. I've been clean 7 years.
All right. Are you satisfied with the advice of your attorney, Mr. Shate, who's here in court today?
I just spoke to Mr.
I
Reedy,
haven't.
but I'm sure he did.
Yes, ma'am.
All right, do you need
I
additional?
didn't speak with him, Judge. I was mistaken.
All right. Do you need extra time to speak to Mr. Shate?
No, ma'am.
All right. Okay, how do you wish to plead to open container and urinating in public?
No no contest.
Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Court's going to take judicial notice of time served in the county jail, withhold on each count. Court costs on each count of $78. I'll give you 6 months to pay. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you.
No, thank
You're welcome.
Next matter would be Timothy Odom, Judge.
Okay, Timothy Lynn Odom, please.
He's approaching, Judge.
I spoke with Mr. Odom, Judge advised him of his
Shake your turn.
and he'd like to take a plea.
I'm sorry, I didn't hear
He'd
you.
like to take a plea of time served, and I advised him of time to pay, and he's asking for 6 months because he has no funds right now.
No problem. Okay, it's one case number. Okay, are you Timothy Odom?
Yes, ma'am.
All right, sir, you have 2 municipal ordinance violations. I have Mr. Shade here, who's your attorney. Court's going to appoint him. You have obstruction by solicitation and no OSHA vest. Your attorney has advised me you want to resolve your case today, sir?
Yes, Your Honor.
All right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, is your name Timothy Lynn Odom, O-D-O-M?
Yes, ma'am.
It's my understanding you can put your hand down. You wish to waive your right to a trial?
Yes.
Anybody forcing you to do this?
No.
Have you had enough of time to speak to your attorney, Mr. Shade?
Yes.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
All right, you understand that you can't go back to North Power Line Road and West Atlantic Boulevard and Panhandle. Do you understand that?
Yes. Yes, Your Honor, I understand that.
Okay, if you go back there, you're going to get arrested, okay?
If I go back there, I'm going to get arrested.
If you go back there and Panhandle, you're going to go back, you're going to get arrested.
How about if I get an OSHA vest and a permit?
If you're allowed to be there, that's fine. If you get an OSHA vest and a permit, then you can be there. If they allow you to be there, okay?
I understand.
All right. All right. How do you wish to plead? 2, obstruction by solicitation and no OSHA vest.
Adjudication withheld, time served.
Yes, how
No.
do you plead? Guilty, no contest.
No contest.
Thank you.
All right. You understand the court's going to adjudicate you today, which means you're going to be convicted of this.
Yes, ma'am.
All right. Okay, so you're pleading no contest? All right, adjudication time served on each count and $78 in court costs on count 1 only. I'll give him 6 months to pay that, okay?
Thank you, Judge.
You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir.
You don't be around if you need it.
Okay. Okay, Osner Dragonis.
Mr. Dragon, come on up. Is your main judge?
Okay, Mr. Dragonis, you have an out-of-state hold for a felony out of, I don't know what this is. It says Wicomico. Maryland? Okay. Out of the state of Maryland, you're going to be held no bond. We'll see you in extradition court, sir, Tuesdays or Thursdays at 1 p.m. Thank you. Next one is going to be, oh, you're dull. Thank you. Lindsay Nicole Kitchen, please.
North Broward, I believe, Judge.
Okay. Hold on one moment. Lindsay Kitchen, please.
She's in North Broward, Judge.
Oh, wait.
She'd like to resolve this matter if possible.
Hello, Mr. McLawrence. All right, state what's your offer?
One moment, Judge. Offered to be withhold court costs, 30 days to take HIV test, receipt of taking the test to be provided to the clerk's office.
To where? The clerk's office.
Yes.
Ms. Kitchen, did you hear the offer from the state?
Yes.
Is that what you'd like to do?
It's, I get out today then?
Yes,
and
ma'am.
I get 30 days, okay, yeah, I that's fine.
You have to take an HIV test and bring the results to the clerk, bring the proof that you took the test to the clerk's office within 30 days. You don't have to tell them what the results of the test are.
That's fine.
And you'll have to pay court costs as well. And if you pick up a third conviction for this type of charge, it can be charged as a felony. Understanding all of that, do you still wish to go forward and resolve the case today?
Yes, sir.
All right, you said withholding court costs?
Yes, ma'am.
All right. All right, ma'am, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Your name is Lindsay, Lindsy, Nicole Kitchen, Kitchen.
Yes, ma'am.
All right, it's my understanding you wish to give up your right to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Ever been treated for a mental illness?
Yes, ma'am.
All right, don't tell me what it is, but does your mental illness affect your ability to understand what's going on today?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings?
Yes, ma'am.
All right, understanding what I just explained to you, you want to plead guilty, not guilty, or no contest to prostitution, lewdness, offer, commit, or engage, first offense.
I think it's no contest, right? No contest.
Mr. Reedy,
Yes, Judge?
she's asking me, is it no contest? I can't give her advice.
Yes, no contest plea would be fine, Lindsay.
All right, and you understand that if you get a third arrest for this type of charge again, it's going to be charged as a felony.
Yes, ma'am.
You also understand that you have to take an HIV test for 30 days, and you only provide the receipt of the test within 45 days to the clerk of court.
Clerk of court, yes, ma'am.
All right, you're going to also have a $293 in court costs that you have to pay within 4 months. Do you understand that?
Yes, ma'am.
All right, and if you don't pay that, I don't know if you heard me say it before, but there's the potential that your driver's license will be suspended if you don't pay it, and then you're going to have a late fee of $25. Do you understand that as well?
Yes, ma'am.
All right, the court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea, withholding court costs, $293. I'll give you 4 months to pay that. As I said, HIV test 30 days. Receipt only, not the results, ma'am. Within 45 days to the clerk's office, the court takes judicial notice of time that you served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, ma'am. Good luck to you. Next one, you're welcome. Jacqueline Denise Brown, please. Jacqueline Denise Brown.
She's approaching, Judge. She's here at me.
Thank you. All right, Miss Brown, good morning, ma'am. How are you?
How are you doing, ma'am?
Fine, thank you. You have prostitution, offer, commit, or engage, first offense, bond set at $300. Court does find probable cause. What say you, Mr. Romero or Mr. Reedy?
Judge, and speaking with Ms. Brown, she's going to be asking the court if you would consider an ROR. She's 50 years old. She's been here in South Florida her whole entire life.
Any objection, State?
She has a record. I gotta see if she has prior failures to appear.
Okay, is her mailing address 925 Northwest 20th? It doesn't say Ave Street or Place or anything, Hollywood, Florida?
Yes, ma'am.
Okay, what is it? 20th what?
I live on 20th Avenue.
No objection.
All right, court's going to ROR you. I'm directing the clerk to update your address to include the word Avenue. Thank you, ma'am. Good luck to you.
Thank you, Judge.
Mr. McLawrence, let me know when you're ready. That's fine. Stacy Smith.
Ms. Smith is approaching, Judge. Come on up, ma'am.
All right, and after Miss Smith is Miss Anna Dones. Oh, good. Okay, Miss Smith, you have prostitution, lewdness, offer, commit, engage, first offense. Court does find probable cause, bond set at $300. What say you, Mr. Romero, Mr. Reedy?
Judge, and speaking with Ms. Smith, she wishes to ask the court if you would consider resolving this case and sending an offer of withhold and taking judicial notice of time served, Judge.
State, what's your offer? They're asking for a withhold on Stacy Smith.
That's fine, Your Honor, just with the HIV test.
I did talk to Ms. Smith about the HIV requirement, Judge. She is aware that she has to submit herself to the exam and submit the proof that she actually just took the exam, not the results, to the clerk of courts. And I did advise her of there's a cost of court costs associated with this case, and that Your Honor would give her 6 months. And at this time, she wishes to accept those terms and resolve her case today.
Okay. All right, ma'am, raise your right hand. Do you swear and/or affirm to tell the truth? Do you swear and/or affirm to tell the truth?
Yes.
All right, put your hand down. Is your name Stacy S. Smith, S-M-I-T-H?
Yes, ma'am.
All right, it's my understanding you want to give up your right to a trial?
Correct.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings?
Yes, ma'am.
All right, you also understand that court has to impose $293 in court costs. I'll give you 6 months to pay. If you don't pay it within that time, there's a potential that your driver's license could be suspended, and you'll also have to pay a penalty late fee of $25. Do you understand that?
Yes, ma'am.
All right. How do you wish to plead? To prostitution, lewdness, offer, commit, engage, first offense? Guilty, not guilty, or no contest?
No contest, ma'am.
Okay. No contest is not saying you did it. It's not saying you didn't do it. It's saying for all intents and purposes you want to resolve this today. Okay?
Right.
All right. All right. So the court's going to accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Withholding court costs $293, 6 months to pay. Court takes judicial notice of the time that you served in the Broward County Jail, HIV test in 30 days, and a receipt, not the results, of the test to the clerk of the court in 45 days. Do you understand?
Yes, ma'am.
All right. Thank you very much. Good luck to you, ma'am. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Anna Milagros Dones, D-O-N-E-S. Whatever you want to do.
I believe North Broward, Judge.
It's in North
Okay.
Broward, Your Honor. I'm going to be asking for pretrial release from Ms. Jones.
Okay. Anna Milagros Dones, please, at North Broward, I believe. Hello, ma'am. How are you?
Thank you, ma'am.
All right, ma'am. You are charged with procure for prostitution, solicit another for lewdness, third subsequent offense. Court does find probable cause. Bond is set at $3,500. Your attorney, Mr. Reedy, who's here in the courtroom from the Public Defender's Office, is asking for standard pretrial supervision. What say you, State?
Your Honor, Ms. Jones is simply just not a good candidate for pretrial.
Do we have a pretrial? Do we have an assessment, risk assessments?
While it's getting pulled, Your Honor, I can tell you she has 23 prior failures to appear in court.
Okay, I'm not going to put her on pretrial if she has 23. Thank you.
Would the court consider reducing her bond? She cannot make a $3,500.
Okay, what can she make?
I don't know what kind of monetary bond she's going to be able to make, quite frankly, Judge. I know she's been living here for 20
I can make
years.
100.
Do you have somebody you can get a hold of, Ms. Stones?
Yes. For $100 bond, yes.
State, what's your response?
I'm sorry, what was the request?
She said she could make $100.
But I don't know if that's 1,000.
Your Honor, the standard bond for felony prostitution is 1,000. That's what I'd be asking for. She has, from what I could see, at least 12 prior prostitution.
All right, court will set bond at $1,000. Thank you, ma'am. Good luck to you.
Thank you.
Is your address 5502 Washington Street, 205 Hollywood?
Yes, ma'am.
All right, good luck to you, ma'am.
Ma'am, I have no way of getting in touch with the person because it's collect calls. I can't make collect calls.
All right, do you have a phone number?
Yes, ma'am.
All right, go to the phone on the left. Mr. Reedy will call you. You can give it to him. He'll make a phone call for you, okay?
Okay, thank you so much.
If she doesn't know a phone number, I'll sign a phone order, Mr. Reedy.
Just to give you the heads up, Your Honor, I'm going to be asking the call case at a turn.
Sure.
Paul Sidlar on page 15.
Sure.
You're done? Thank you.
Sir Sidler is here, present, Judge, at May.
All right, let me find the paperwork. Give me a moment.
Yes, Judge.
All right, what page are we on now?
Page were we on? I think we were on 2 or, no, sorry, 3, on page 3.
Okay.
But Mr. Sidler is on page 15, Judge.
Yeah, I can't. Stuck to something. Hold on. Okay, here he is. All right. Okay, are you Paul Danielle Sidlar?
Paul Daniel Sidler. Yes.
All right, sir. You have 1 count of attempted murder, no bond hold, and you have false imprisonment an adult. Court does find probable cause. Let's talk about bond state and any special conditions.
Your Honor, I'm going to be requesting the court find proof evident or presumption grade on count 1 for attempted first-degree murder. I do have, in addition to the probable cause affidavit, I have Detective Deborah Levy from the Hollywood Police Department, who authored the probable cause affidavit present to provide testimony.
Sure. All right, raise your right hand. Do you swear and/or affirm to tell the truth? All right, state your first and last name and who you're employed by and what's your position.
My name's Deborah Levy. I'm a detective with the City of Hollywood Police Department.
Detective Levy, were you assigned to investigate the charges that Mr. Sidlar has been arrested for and is before the court on today?
Yes, sir.
Okay, I just want you to, one, advise the court, are you aware of the victim's, what condition she is in at the hospital presently?
Presently, she's in the ICU unit in stable condition.
And did you have an opportunity to speak with medical personnel regarding her condition?
Yes, I did.
And what were you specifically told by medical personnel about her condition when she was brought into the ICU?
I was told she was lucky to be alive.
Your Honor, based on the testimony, and the reason I provided that testimony is I think it goes to that the alleged violence committed by Mr. Sidlar does rise to the level of attempted murder, premeditated murder, also considering the evidence that he several times made statements that he was going to kill the alleged victim.
Well, I see it says she was able to climb on the bed and he would beat me again, and it seemed like it never ended.
And I'm referring to, specifically...
No, I understand.
Okay,
It says trying to leave him and berating her went on for approximately 3 days. He literally beat the whatever out of me every time I tried to leave, so.
Yes, and then the very next sentence in the next paragraph.
Points taken. Thank you. Okay. All right, so, Mr. Reedy, what say you?
Your Honor, we would object to the court making a finding of proof evident presumption great based on what's been presented here this morning. That is the highest standard of proof we have in the criminal justice system, higher even than proof beyond a reasonable doubt. We have a probable cause affidavit that is designed to determine probable cause. The state has introduced no physical evidence, no medical reports, nothing to verify the story of this woman, and we would ask the court to set bond for Mr. Sidler in this case.
All right, Mr. Sidlar, I have reviewed the probable cause affidavit filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great on the attempted first-degree murder charge. We're going to get to the false imprisonment in a moment. Therefore, on count 1, you're going to be held without bond until further order of court. This order is without prejudice, sir. For you to file a motion to set bond with your assigned division judge and request a hearing under the case of State v. Arthur. State, what say you on count 2?
Your Honor, one moment. Your Honor, I'm going to be asking for bond in the amount of $100,000 on count 2, based on the totality of the circumstances of this case. Also, just to advise the court, I'm showing that Mr. Sidlar is currently out on pretrial, being supervised by pretrial release. He was placed on pretrial release July 4th of this year for charges of resisting an officer without violence, and a municipal ordinance for disturbing the peace.
Okay, what's the case number?
186260.
Hold on, 18, I'm writing it down, I'm
No
sorry.
problem. 186260 MO10A and 186259.
Hold on, 18,
6259
okay,
MM10A, and he's being supervised by pretrial services
okay,
on those two cases.
all right. All right, so what say you, defense?
Judge, based on the court, I believe finding proof evident presumption great and holding him no bond on count 1, we're going to be deferring a future argument regarding bond on count 2. So we just asked you to set a reasonable bond under the circumstances, Judge.
Okay, and the court's also going to order no victim contact, direct or indirect, with the alleged victim in the case with the initials DMD. What that means, sir, is there's no contact in person, calling, texting, writing, nothing on social media whatsoever, no messages through third parties, and nothing in writing. So, and I want everybody else, when I tell you it's no victim contact, direct or indirect, that's what it means. I will ask you, if you've heard me tell Mr. Sidlar what it means, and if you need me to repeat it again, I have no problem, I'll do that. So, court is going to do this. Court is going to do a $100,000 bond on count 2, no bond on count 1, on the 2 pending cases for the case number 186259 MM10A. The court will revoke his bond and set bond at $2,500. And on case number 186260 MO10A, does anybody know where that is?
They're assigned to?
Fort Lauderdale, or it is? All right, I'm gonna appoint Mr. McLawrence if he's not appointed already on it.
No, actually, it's Hollywood.
It is?
Yeah, it has an MO10A because it's
Here.
had a misdemeanor state.
But you looked it up, it is,
It's Hollywood.
okay, let's
And
appoint
it-
Mr. Shade on that case.
He's
I'll
already
give
been
you-
he's already been appointed, Judge.
He has, okay.
Yeah, I'm looking at an Odyssey right here.
All right. All right, and in that case, court's gonna set bond at 1,000, okay. So here you go, Ms. Patrice. On these two. Anything else from anybody?
No, Your Honor.
Okay. All right, thank you very much. Good luck. Thank you, Detective, for coming in. Engel Tina U. Gomez Quiros. Gomez Quiros.
Bonded, Judge.
Bonded, okay. Next one is Kelly. Mr. McLawrence ready yet? Okay. Kelly David. I'm sorry, what'd you say?
She bonded, Judge, that's what I said.
Thank you, everybody.
You're welcome. Ms. Morales,
Valerie
come on up,
Jeanette
please.
Morales, please.
She's approaching, Judge. She got me.
Okay. Okay, are you Valerie Jeanette Morales, ma'am?
Yes, ma'am.
All right, you have burglary with assault or battery. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim in this case with the initials BJSV. Did you hear me say what no victim contact, direct or indirect means? If you need me to explain it again, it's not a problem.
No.
Okay, you heard me? Okay.
Yes, ma'am.
All right, state.
Your Honor, I'm not going to be asking a no bond hold on Ms. Morales. I spoke with the alleged victim, and she has no opposition to the court setting a bond with no contact order. I would just ask if the court would advise Ms. Morales the potential consequences if she violates this court's no contact order that I imagine the court will issue. Your Honor, my concern really in this case, though, it's a punishable by life offense, obviously. I'm concerned that Ms. Morales may have some anger issues. She was arrested April this year for a domestic violence battery that was dropped. You see here, there was an independent witness of this incident that corroborates the victim's story that Ms. Morales first started punching this woman's door, then opened her car door and started punching this woman while she was inside her car. This while Ms. Morales' own infant child was in her own car.
And it says that it didn't stop.
No. I'm gonna be requesting a $10,000 bond.
Okay. Defense?
Judge, what is the bond amount that the state suggested?
10,000.
Yes, Judge. Judge,
And there's no victim contact I already ordered. Direct or indirect.
Judge, we're not off. I mean, we're gonna be asking for $5,000. This is why, Judge, she's 21 years old, been living in our community for about 5 years right now. She graduated from Sheridan Tech in culinary hospitality, and she obtained employment in Publix working at the bakery. It's part-time work. She's making about $12 an hour. She's a graduate of Plantation High School, class of 2016. She lives locally here in Oakland Park. She is a single mother. She has a 7-month-old child. Her share of the rent is about $200 per month. So as you can see, the funds are limited. She's going to be contacting her boyfriend who works for FedEx, and that's the person she's going to be relying on to post her monetary bond. She believes that the boyfriend goes through a bondsman, that maybe he can come up with $5,000, and that is the reason why we're asking for $5,000 on Ms. Morales' behalf.
All right, based on the totality of the circumstances, including but not limited to, that someone had to pull her off of this person, there was a child in the car, and the level of violence, court's going to set the bond at $10,000. Good luck to you, ma'am. Susie Jaboham.
Mr. Jaboham, come on up, please.
Okay, Ms. Jaboham, you have dealing in stolen property, $3,500. Driving while license is suspended, third or subsequent offense, $750. You do have capious traffics, 4 of them. And I'll tell you what they are in a moment. You have a no bond hold from Judge Hurley for driving while license is suspended. You have a no bond hold from Judge Christopher Pohl, driving while license is suspended. You have a suspended driver's license from Judge Pohl, no bond hold. And you have a suspended driver's license from Judge Melinda Brown with the $500 bond. What say court does find probable cause. You do have a hearing in Division MH, which is Judge Christopher Pohl on July 20th at 9 a.m. That's this Friday. And you do have one in front of Judge Melinda Brown on July 26th at 10 a.m. So you have $3,500, $750, 3 no bond holds, and 1 $500 bond. What say you, defense?
Judge, I'm going to be asking you just specifically on count 1. I do realize count 2 is the driving while license suspended, third or second offense, and that the counts 3, 4, and 5, and 6 are related to the same type of charge. So I'm not going to be asking you to modify none of those counts. However, on count 1, if when she goes to court on the 20th and 26th, and if she's able to deal with those issues, she's going to be contacting her friend to help post her monetary bond. She doesn't believe that her friend can quite afford the $3,500 bond. We'd be asking you to consider lowering it to $1,500. At this time, Ms. Jobaham lives with her friend, but her friend lives locally in Fort Lauderdale. I believe she receives housing assistance. Unfortunately, Ms. Jobaham at this time is unemployed. So financially, she's going to be just relying on her friend to help post her bond. I know Ms. Jobaham is a single mother, Judge. So I think what I'm asking as far as just a decrease of $2,000 on count 1 is reasonable.
Okay, so you're asking for $1,500, you said?
Yes, Judge, just on count 1 alone.
All right. $1,500 on count 1, $750 on count 2. No bond holds, Judge Pohl, Judge Hurley, and Judge Pohl again. And then the $500, Judge Brown. So total bond is $2,750. And ma'am, you don't have an address here. Is there a mailing address? The last one you have is the 720 address. No, I'm sorry, 920 Northwest 7th Ave. Do you have a correct or updated mailing address of a friend or family member or your place?
889 Northwest 16th.
Say it again.
What is it?
889 Northwest 16th Avenue, Fort Lauderdale, Florida. 33311.
889 Judge Northwest 16th Avenue, Fort Lauderdale, Florida. 33311.
Is there an apartment number?
It's the first one.
Is this a house or apartment?
It's a house that's split into two.
It's a house. So just like that, you
Yeah,
can
it's
get
like
mail.
a business, yeah.
Okay. Just like the way we enunciated the address, Judge, that's the way she's going to receive the mail.
Okay, thank you. Look, ma'am. Anthony Mastropolito?
North Broward.
I believe North Broward.
Mr. Polito.
Mr.
Okay.
Mastropolito would like to resolve this matter if possible, Judge.
All right. I'm not going to resolve this case today based on the facts. I mean, I have a concern about the comments with the little girl.
Frankly,
Your Honor, I only said
first,
that because
Sir,
I.
don't talk about
don't
the
say
facts of your
anything,
case.
sir.
You have Mr. Reedy here. You have the
I just
right
wanna
to, sir,
talk.
you have the right to remain silent. Anything you say or do
No.
can and will be used against you.
I know. I just wanted them to come here, and I went to an extreme. That's all. I made that up to get them there. That's all.
Don't say
Really.
anything about the facts of your case, sir.
It's the truth.
Your Honor, my first impression was that this should probably get transferred to Judge Lerner.
Yeah, I agree.
No, I went to the extreme to get them there. That's all.
Okay.
I made that up because
All right.
I wanted them. I called many times and they wouldn't come. I needed them really.
All right,
I
sir,
don't-
court finds probable cause. Your
Can I
attorney
have
is also,
ROR?
I'm not RORing you, I'm leaving the bond in place. I am gonna transfer you to Judge Lerner Wren. When can we get him a court date?
I'll text her JA and I'm sure they will schedule him as
This-
at the
Okay,
next available
you should be
date.
getting in front of Judge Wren within the next couple of days.
I made something up to get them there, though, Your Honor. It's nothing. This is all.
Sir, do not discuss the
blown
facts
out
of your
proportion.
case.
It was blown out
believe
of
this
proportion. I
hearing
was trying
is
to get them
concluded,
there
Your Honor.
because I wanted them to get there because there was something else about the turtles and.
All right,
Really?
$100 bond, sir, thank you.
Your Honor, I'm going to please the court. I have another witness now present. If I could call a case out of turn.
Sure.
This is
Cameron
all blown
McGirt.
out of proportion, Your Honor. There was no little girl. I made that up because I knew the cops would come if I said something like that.
All right, sir,
Please.
you're not
understand
helping
that.
yourself. You're gonna see
I
Judge
wait.
Wren in a day or two, okay?
For what?
Are you calling him?
Okay, we're done.
This is.
Your attorney's calling you, step to the left, sir. Sir, your attorney is calling
I'm
you,
not
step
calling
to the
him.
left.
I'm not calling him, Judge.
Oh, you're not? I'm sorry.
I needed the police and they wouldn't come. I needed them.
All right, sir. Thank you very much. The hearing's over. You'll see Judge Wren, okay? Good luck to you. Good luck to you. All right, who do we have and where are they?
Cameron McGirt on page 19, Your Honor.
MC?
Yes, ma'am.
Okay, Madam
Cameron
Clerk, if you
McGirt.
could swear in this gentleman?
19.
Yes, I do. Detective John Kidd, K-I-D-D.
And who do you work for?
City of Hollywood.
Thank you.
And good morning, Detective Kidd.
Hold on, let me
Oh,
find the paperwork.
Sorry.
That's all right. Okay, Cameron Lorenz McGirt.
Yes, ma'am.
All right, let me just tell him, Mr. McGirt, you have counts 1, 2, 3, 4, and 5. You have robbery with a firearm. There's no bond holds. You also have a probation violation. You are going before your division judge on July 24th, which is this coming Tuesday at 8:45 a.m. That's Judge Edward Merrigan this Tuesday, July 24th at 8:45 a.m. Court does find probable cause. The court also is going to order no victim contact, direct or indirect, with the alleged victims in the case. Do you need me to explain what no contact, direct or indirect means, sir, with the alleged victims in the case? I don't mind explaining it again. No? All right, so that is, the alleged victims' initials are BABD, AIC, MS, HEM, and VAP. Do you understand, sir? No victim contact? Yes? I didn't hear him, Mr. Romero. Okay. All right, so State, what say you on counts 1 through 5? What are you requesting?
Your Honor, I'm going to just ask if I can provide some testimony from Detective Kidd before I seek finding proof evidence of presumption.
Okay.
Thank you. Detective Kidd, in what capacity are you employed by the City of Hollywood?
I'm a detective assigned to the Violent Crimes Unit.
And how long have you been a detective for the city of Hollywood?
In different positions, about 15 years.
Okay. And were you assigned to investigate allegations of robbery of a firearm of 5 different victims that occurred on June 28th of this year at 2350 Sims Street in Hollywood?
Yes, I was.
And you authored a probable cause affidavit for those charges for the arrest of Cameron McGirt?
Yes, I did.
Okay. Detective Kidd, in your probable cause affidavit, you mentioned that a victim with the initials BD was able to identify Cameron McGirt even though he was wearing a mask. How was she able to do so?
After speaking to her, well, initially the name was in the initial police report because she took it upon herself to get a BSO deputy to get his name. So she, knowing him, went to a BSO deputy to get his last name. She wasn't positive about the last name. After identifying his last name, she called, BSO called us back. The initial police officer put that in the initial police report. I then interviewed her thereafter, questioning about that, and she stated she grew up with him in the neighborhood, knew exactly who he was, and in her sworn statement, she kept using the word, catching his voice when she was confronting him inches away from his face, and at no time did he ever push her back, point the gun at her or anything. It was clear that he knew her as well.
So to be clear, she advised you when she gave a sworn statement that she recognized his voice?
Oh, absolutely, yes.
And anything else about him physically that did she recognize?
She did say nothing. Another witness that did not know him stated that he definitely saw specific tattoos, detailed him in detail, and documented in the probable cause affidavit. And yesterday after his arrest, I verified that myself at crime scene. We took initial photos of those detailed tattoos, and they were exactly verbatim of what the second victim stated.
There's nothing further here.
Okay. All right, so you're asking on counts 1 through 5, proof, evident, presumption, great?
Yes, Your Honor, based on the probable cause affidavit and the sworn testimony from Detective Kidd.
All right.
In light of the no bond hold on Mr. McGirt on count 6, the defense would defer any argument regarding proof, evident, presumption, great, until Mr. McGirt can appear in front of his division judge.
All right, Mr. McGirt, I have reviewed the probable cause affidavit and heard the testimony of the detective here and filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, sir, on counts 1 through 5, robbery with the firearm, on each count, you're going to be held no bond until further order of the court. This order is without prejudice, sir, for you to file a motion to set bond with your assigned division judge under the case of State v. Arthur. No victim contact, sir. And on count 6, the no bond, the probation violation, you're going to be held no bond on that as well. Good luck to you, sir. Thank you, Detective, for coming in.
Anytime.
All right, Ms. Patrice, do we need to change that? Remember yesterday? There was an order and the public, Ms. Chase left. Do we need to change that?
No, it's gonna go, it's actually.
Don't worry about it.
Going to court in 30 minutes.
I'm going to hold on to it just in case.
No problem.
All right.
That was something that I didn't have asked for, but it's going to court in 30 minutes.
Okay. All right, so who do you have, Mr. McLawrence?
Judge, I have Jessica Brandon. She's in the Paul Ryan facility
Jessica Brandon, I have.
on page 3 of the docket.
Oh, okay, I have that.
All right, Mother.
I have Jessica Brandon, Samudio, Faison, and then I have Kenneth Zachary.
Yes.
But I also have a municipal ordinance. This is Pompano Beach.
Pages 6 and 17. That's Zachary. Yes.
Okay, give me just one moment.
Judge, in reviewing her file, I did see a motion that was filed by an attorney by the name of Scott Rubenchick. He doesn't look like he was the attorney of record, but I did make contact with him, and he told me that's fine, we could go ahead and resolve the case here today. And I spoke to Ms. Brandon, and she likewise wants to resolve this matter. Just so the court is aware, it's a 2016 case. It involved the alleged theft of baby formula from the Walmart in 2500 West Broward Boulevard. All the items were recovered, Judge.
Okay, State, what's your offer? Oh,
Your Honor,
it's an MO, I know.
oh, okay, is it? I didn't know if this.
What's her prior history?
1 moment, Judge. I got it. Thank you.
Okay, Mr. McLawrence, I signed the 3 orders of meeting.
There was an arrest in Georgia from June of last year for forgery and ID theft. There's no disposition. They're both felonies and might still be pending. I can't be certain. Other than that.
Okay, this could affect her case in Georgia. Did you discuss that with her? Is it something you'd like to?
Yes, Judge, I didn't know anything about it.
All right, so let's pass this case. Ma'am, step over to your right. Mr. McLawrence will call you, okay? Why don't you call her now, and then we'll call your 2 cases in a moment. Thank you. All right, Terry DeRon, Washington. And if she wants to resolve it, it's going to be an adjudication. Make sure you tell her her defense is a felony.
Judge, Mr. Washington is here at Maine.
Okay. All right, Mr. Washington, you have petty theft, first degree, bond set at $100. Court does find probable cause. Court is going to order no return, sir, to the Walmart at 2300 West Atlantic Boulevard, Pompano Beach. Do you understand, sir? If you go back there, you will be arrested.
Yes, ma'am.
All right. What say you, defense?
Judge, Mr. Washington is asking to inquire if the court would consider resolving his case today.
State, what are you offering?
State's offer would be an adjudication, time served, no return to the Walmart.
Now you understand with petty thefts, on your 3rd conviction, they could charge it as a felony. Do you understand?
2300 West Atlantic Boulevard, Judge.
And you have court costs. So if the judge agrees to resolve this case, she's going to give you 6 months to pay the court costs. And if you don't pay court costs, the driver's license gets suspended. Do you understand?
What's the court cost?
$293.
That's a lot, eh?
That's what the court cost is. She can't come to court. Court costs. Okay, do you understand?
We can hear you, Hector.
Oh. Thank you, Judge. And speaking of Mr. Washington, he wishes to accept the state's offer as far as an adjudication time served. I did explain to him as far as upon his 3rd conviction with the petty theft that basically the state could choose to file it as a felony offense. I did speak to him about court costs. Mr. Washington's concern was he's not sure he's going to be able to pay the court costs within that. Not so soon, as he said, within the 6 months. We're going to be asking the court to consider granting him a year to pay the court costs, Judge.
No problem.
Can I give you my address?
Oh, yeah. The judge
All right, sir, raise your right
hand.
hand. Do you swear and or affirm to tell the truth?
Yes, sir. Yes, ma'am.
All right, put your hand down. Your name is Terry DeRon Washington, W-A-S-H-I-N-G-T-O-N.
Yes, ma'am.
All right, it's my understanding you wish to give up your right to a trial and resolve your case today?
Yes.
Anybody forcing you to do this?
No, ma'am.
You under the influence of any alcohol or drugs or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes.
You understand, and you also spoke to your attorney about if you get arrested for a 3rd theft charge, even though it's a misdemeanor, they could charge it as a felony.
Yes.
All right, you also understand you can't go back to Walmart, and I'll give you 1 year to pay the $293 in court costs, and you heard your attorney talking about your driver's license suspension. You understand all of that?
Yes.
All right, so keeping all of that in mind, how do you wish to plead to petty theft, first degree, Property between 100 to 300. Guilty, not guilty, or no contest?
No contest.
Okay, court's gonna accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication time served, $293 in court costs, 1 year to pay. No return to the Walmart, sir, with the location I stated. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Did you say you wanted me to update your address? Because I have 357 Southwest York Avenue, Lamont, Florida.
Yeah, I want to update it.
Okay, what is it, sir?
5226.
Say it slow.
5226.
5226.
Northwest 24th Court. Lauderhill, Florida. 33313. Mailbox 105.
Okay.
All right. Good luck, sir.
Thank you, sir. Good luck to you. All right, we're back on. You ready on Jessica Brandon?
Yes, Judge.
All right, Paul Ryan.
So Judge, I'm not sure if, I know that the state mentioned to you about the 2017 case in Georgia. This particular case happened before that Georgia case. This is a 2016 case. This would be Ms. Brandon's first offense, I believe. And Judge, I say all that to say, Judge, we would request a withhold as opposed to adjudication. And if the court is not inclined to do the withhold, we're going to ask if the court would be inclined to ROR Ms. Brandon or to place her in pretrial release.
What's the 170 Southwest 8th Avenue, Southwest 8th Street, number 7, Pompano?
That's her current address.
All right. All right, ma'am, every time you move, you have to update your address.
I have, yes, ma'am, I understand. I have updated it with the attorney that I'm utilizing in Georgia.
All right, so let me do this. 170 Southwest 8th Street. If you move, ma'am, you have to notify your attorney and the clerk of the court in writing.
Yes, ma'am.
And she's represented by Scott Rubincheck on this?
Judge, it doesn't
on
look
this
like
case?
it. It doesn't
No?
look like it.
No, I'm sorry.
Okay. All right, you do have a court date of July 23rd at 11 a.m.
Correct. I spoke with the public defender from Georgia, and they confirmed that I don't need to be present for that hearing.
No, it's for here.
Oh, for here? Oh, no, I wasn't aware of that. See,
it's for Judge Robert. It's Judge Robert Diaz. So, want to? Do you have Mr. McLawrence's number?
No, she doesn't, Judge. I was going to ask if I could give it to
Okay,
her.
Deputy.
Yes, Your Honor.
Can we? Can you write down 2 things for Mr. McLawrence in the court?
Sure.
We have to give something to Miss Brandon.
No problem.
Okay, you want to give him your number?
Sure, Judge. It's 954-318-1376.
Yes.
Sorry, I didn't hear you?
Yes, I have it.
Okay, thank
All
you.
right, and then she has a court date before Judge Robert Diaz. He's the 6th floor. If you don't show up, ma'am, he's probably going to do a no bond hold. So if I were you, I'd show up to court on, Deputy, if you could write this down, Judge Robert Diaz, D-I-A-Z, July 23rd at 11 a.m. Do you have her number, Mr. McLawrence? Maybe you want to take a phone number? Do you have a cell, ma'am?
Do you have a cell phone?
I do.
Okay, I'll call. Get a number.
All right. All right, step to the right, ma'am. ROR. Don't miss your court date.
Thank you.
Thank you. Ma'am, don't go back yet. We got to take care of another case, and Mr. McLawrence has to call you for the phone number.
Affirmative, thank you.
Okay? Wesley Ellis Leach. Or wait.
There's Jonathan
Sorry.
Samudio face on. It's okay, Judge.
Picked up the wrong one.
He's over.
Jonathan Samudio, Facey son.
He's in North Broward.
Okay.
Good morning, ma'am. God bless.
Okay. Mr. Reedy, is there any way you could call Paul Ryan and just get the number from that lady?
I can, Judge.
So we can let her go back? You don't hold up the... All right, you have a municipal ordinance. It's page 6. Let's see.
Hey, Deputy.
Yes, ma'am, Ms. Velasquez.
This is a 2018 case. This is for trespass.
Yes, ma'am.
Okay, we have your attorney here, Mr. McLaurin, sir, so don't say anything.
Yes, ma'am.
All right, so this was the Shell gas station. Court finds probable cause, bond set at $25. What say you, Mr.
Judge, I spoke to Mr. Faison, or Samudio Faison, and he indicated to me that he would like to resolve this. He told me he's employed, he wants to get back to work.
What's her name?
All right, does he understand that he can't go back to the Shell station?
Yes, ma'am, I do.
All right, if you go back there, sir, what do you think's gonna happen?
I'm gonna come back right before you again. I don't want that to happen.
All right, so no return to the Shell station, withholding court costs.
Yes, ma'am.
All right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am, I do.
All right, your name is Jonathan Samudio, Samudio-FACYSON.
Yes, ma'am.
All right, it's my understanding you wish to resolve your case today.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
You under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You've had enough of time to speak to your attorney, Mr. McLaurin.
Yes, I have.
You understand that the court has to impose court costs today, and if you don't pay them within 6 months, driver's license could be suspended, you could be arrested for that, and then you'd have to pay a late fee as well. Do you understand that?
Yes, ma'am. Well aware.
Okay. All right, how do you wish to plead to trespass, sir? Guilty, not guilty, no contest.
No contest.
Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea, withholds court costs. I'm sorry, not $293, $78. I wish you would have corrected me, Mr. McLaurin.
Just caught it.
Yes,
Yeah,
ma'am.
$78 in court costs. This is a municipal ordinance. I'm sorry. 6 months to pay, no return, sir, to the Shell located at 88 West Sunrise Boulevard,
Fort Lauderdale, Florida.
Fort Lauderdale, Florida. Thank you very much, sir. Good luck to you. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. The court also is going to take judicial notice of the time that you served in the Broward County Jail. Good luck to you, sir.
Thank you. God bless you.
Thank you. All right. So next one is going to be Kenneth Zachary. Do we know where he is? Page 17?
North Broward.
North Broward. Thank you.
You're welcome, ma'am.
Good morning, Mr. Zachary. How are you?
Morning, ma'am.
All right, Mr. Zachary, you have a bunch of charges here. You have false ID given to a law enforcement officer, $100 bond. You have warrant for a VOP pretrial felony. You have 2 no bond holds or not for a magistrate. You have a capious felony with a no bond hold. You have a capious misdemeanor with $250 bond and another capious felony with a no bond hold. You are going before your division judge, Judge Tim Bailey, on July 23rd at 9 a.m. And you're also going before your other judge in the misdemeanor division this Friday at 9 a.m. So the misdemeanor is Friday at 9 a.m. and the felony is this Monday at 9 a.m.
So, Judge, I got violation pretrial, huh?
Yes, sir. Don't say anything. We have your attorneys here.
Yes, I spoke with Mr. Zachary before court, Judge, and Ken, we're going to look into your medical issues, okay? So meanwhile, just sit tight. You'll be in front of Judge Bailey later this week.
All right, so on count 1, the court's going to set bond at $1, and the capious on count 5, $249. All the other bonds, no bonds remain in place. Thank you, sir. Good luck to you. Thank you, Mr. McLaurin. Mr. Reedy has that number for you. And thank you, Mr. Reedy, for doing that.
My pleasure, Judge.
All right, Wesley Ellis Leach, please.
Here at Main, Judge, he's approaching.
All right, Mr. Leach, you have trespassed property, not a structure or conveyance. Court finds probable cause, $25 bond. What say you, Mr. Romero?
Judge, in speaking for Leach, he's wishing to ask the court if you would consider resolving this case today.
He's been trespassed a few times before, and he keeps going back to this racetrack. State, what's your offer?
It would be time served, Your Honor. No return.
Okay, what's going to stop him from going back there? If he goes back there again, I'm not going to agree to a time served.
Judge, he understands not to go back.
Okay. All right, Mr. Leach, raise your right hand. Do you swear and/or affirm to tell the truth?
I swear to tell the truth.
All right, put your hand down. How old are you, sir?
22.
All right, your name is Wesley Leach, Leach?
Yes, ma'am.
All right, you know what happens if you go back to the racetrack?
I'll be arrested.
All right, it's my understanding you wish to give up your right to a trial and resolve your case today?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of alcohol, drugs, medication, or ever been treated for a mental illness? All right, you understand I have to impose court costs of $293. I'll give you 6 months to pay. If you can't pay them within the 6 months, they can suspend your driver's license and also issue a late fee of $25. Do you understand?
Yes, ma'am.
All right, understanding what I just explained to you, how do you want to plead? Guilty, not guilty, no contest to trespass property, not structure or conveyance.
No contest.
Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Court's going to adjudicate time served, $293 in court costs, sir. I'll give you 6 months to pay that. No return to the racetrack, 599 West Atlantic Boulevard, Pompano Beach. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you.
Good luck, sir.
Storm Octavius Tillman, please.
Mr. Tillman's
How
in
you
North
doing?
Broward, Judge.
Your Honor, how are you?
I'd like to resolve this case to a withheld adjudication if possible today.
Okay, are you Storm Tillman, sir?
Yes, Your Honor.
All right, sir, you're charged with possession of cannabis, 20 grams or less. What's your recommendation, State?
It would be a withhold court cost.
Mr. Tillman, are you willing to give up your right to a trial and all the other rights to
Let me
go
just
along
put
with that and not
Sir,
fight the
raise your
case?
right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, your name is Storm Octavius Tillman, Tillman?
Yes, ma'am.
All right, you may proceed, Mr. Reedy.
Thank you, Judge. Mr. Tillman, are you willing to give up your right to a trial by jury, enter a plea of no contest, and accept the state's offer of a withheld adjudication and court costs?
Yes, sir.
If you don't pay the court costs, it could have an adverse effect on your driver's license. Do you understand that?
Okay, sir.
Okay, and the judge will give you time to pay.
It's actually
Okay.
308 for possession
How
of
much is it,
marijuana.
308?
Yeah.
It's $308. How much time do you need to pay that, Mr. Tillman?
Your Honor, give me about
6 months?
360. 180 days would be good.
Okay, 6 months. All right, sir. Are you under the you can put your hand down. Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
Yes, ma'am.
Don't tell me what it is, but does your mental illness affect your ability to understand what's going on here today?
No, ma'am.
You've had enough of time to talk to your public defender, Mr. Reedy?
Yes, I have, ma'am.
All right, how do you wish to plead to possession of cannabis, 20 grams or less? Guilty, not guilty, no contest.
No contest.
Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Withhold of adjudication and court costs of 308, 6 months to pay. Court takes judicial notice of the time that Mr. Tillman has served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed, sir. Thank you very much. Good luck to you.
Good luck, Mr.
Sabi and
Tillman.
Tyson, you're welcome. Sabi and Tyson, please.
Bonded, Judge.
Benjamin Allen Moore, please.
Mr. Moore is approaching, Judge. You see our main.
Okay, Mr. Moore, you have trespass, unoccupied structure, or conveyance. Bond set at $25. Court does find probable cause. Court's going to order you, sir, not to go back to the East Police Station in Pembroke Pines. Do you understand?
Yes, ma'am.
Okay. What say you?
And speaking with Mr. Moore, he wishes to resolve the case today.
Okay. All right, State, what's your offer?
One moment, Judge. Your Honor, the offer, he has priors from other states. The offer would be adjudication time served.
Okay, adjudication time served, court costs.
He wishes to accept the state's offer, Judge.
Okay, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right, your name is Benjamin Allen Moore, M-O-O-R-E.
Yes, ma'am.
It's my understanding you wish to give up your right to a trial and resolve your case today?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, medication, or ever been treated for a mental illness?
No, ma'am.
You understand that the court's going to have to impose $293 in court costs. I'll give you 6 months to pay. If you don't pay it, there's a potential that your driver's license will be suspended, and you'll also have to pay a late fee of around $25. Do you understand that?
Yes, ma'am.
All right, how do you wish to plead to trespassing, occupied structure, or conveyance? Guilty, not guilty, or no contest?
No contest.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication time served, $293 in court costs, 6 months to pay. Not going to tell him not to return because it is a police station. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. Good luck to you, sir.
Thank you, ma'am.
You're welcome. Negus Nathaniel Vickers.
Mr. Vickers?
Mr. Vickers, come on up, sir. Then after him is Marquise Joel Johnson, and then we have Jonathan Andrew Henley. All right, are you Mr. Negus Nathaniel Vickers?
Yes.
All right, sir, you have possession of cannabis, less than 20 grams. Judge Hurley set bond at $1,000. Court does find probable cause. What say you, Mr. Romero?
Judge, he's going to be asking the court to consider resolving this case today.
Your Honor, the documented offer from the assigned assistant state attorney from June of this year is withholding court costs.
Okay, withholding court costs, $308. I'll give him 6 months to pay.
He wishes to accept the court's offer, Judge, or the state's offer.
All right, Mr. Vickers, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right, your name is Negus, N-E-G-U-S, Nathaniel Vickers. Vickers, V-I-C-K-E-R-S.
Yes.
It's my understanding you wish to resolve your case today and give up your right to a trial?
Yes.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings?
Yes, ma'am.
All right. You understand that I have to impose $308 in court costs. I'll give you 6 months to pay. If you don't pay, there's a potential your driver's license will be suspended, and you'll also have to pay a $25 late fee. Do you understand that?
Yes, ma'am.
Satisfied with the advice of your attorney, Mr. Romero?
Yes, ma'am.
Need additional time to talk to him?
Do you need more time to talk to me? No?
Okay, I'll take a as a no. All right, how do you wish to plead? Guilty, not guilty, no contest to possession of marijuana under 20 grams or less?
Guilty.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Withholding court costs, I can hear somebody talking. Turn off your mic, State. $308 in court costs, 6 months to pay. Court takes judicial notice of time served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. Marquise Joel Johnson. Good luck to you, sir. Marquise Joel Johnson, and then we have Jonathan Andrew Henley.
Bonded, Judge.
Okay, Jonathan Andrew Henley.
Bonded, Judge.
What about Marquise Johnson too?
Bonded, Judge.
All right. Philippe Arvalo.
Mr. Arvalo, come on up, please.
And after Mr. Arvalo is Fulgencio Anavate. Okay, Mr. Arvalo, you have 2 capious misdemeanors, bond set at $500 on each one. You have a possession of cannabis under 20 grams, and you have suspended driver's license. First offense, you didn't show up for calendar call. They're both in Division MQ, which is Judge Gottlieb, which is to be set in his division. Anybody wish to be heard?
Yes, Judge. And speaking, Mr. Arvalo, my understanding is that he actually missed court. He came to the main jail and actually turned himself in. Judge, at this time, Mr. Arvalo is asking if the court would consider resolving his case for withheld judicial notice of time served.
He has 2. Driving while license is suspended and the possession of cannabis. So you're saying a withhold on both of them?
Correct, Judge.
Okay. Ready?
Yes, Judge.
Oh, okay. All right, sir, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, I do.
All right, put your hand down. Your name is Felipe Arvalo, Arevalo.
Yes, ma'am.
All right, it's my understanding you wish to resolve your cases, both your cases today, with suspended driver's license and the possession of marijuana under 20 grams?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Have you had enough of time to speak to Mr. Romero?
Yes.
All right, you understand that if you get a 3rd driving while license is suspended within a 5-year period, you'll be a habitual traffic offender, and then you can't drive for 5 years. You understand that? And if you do, it'll be a felony.
Understood.
All right, understanding what I just explained to you. You want to plead guilty, not guilty, or no contest?
No contest.
All right, you understand in each case, even though I withhold adjudication, I have to impose court costs. For the possession of marijuana, I have under 20 grams, I have to impose court costs of $308. And for the driving while license is suspended, I have to impose court costs of $293. How much time do you need to pay that, sir?
6 months. 6 months.
All right, I'll give you 6 months to pay on each one. And you understand that if you don't pay, it's going to be another suspended driver's license. You understand that, sir?
Yes.
All right. And there will be a late fee of approximately $25. So you want to plead guilty, not guilty, no contest, sir?
No contest.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Case number 16-14250 TC40A. Court's going to withhold adjudication and impose court costs of $293. And in the possession of marijuana case, case number 18-4375 MM10A, court's going to withhold adjudication and impose court costs of $308. The court takes judicial notice of the time that Mr. Arvalo served in the Broward County Jail, and I'm going to give him 6 months to pay on each one. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, sir, one will be appointed. Thank you very much. Good luck to you. Fulgencio Anavate.
Bonded, Judge.
Joseph Cunningham, please.
Mr. Cunningham, come on up, please. Come on up.
And after Mr. Cunningham is going to be Fidel Alejandro Rivas.
Your Honor, after the court makes a finding, if I could provide some information to the court?
For Joseph Cunningham?
Yes.
All right. So, Mr. Cunningham, how are you today, sir?
I'm doing all right, ma'am. Thank you.
Okay, Mr. Cunningham, you have a capious misdemeanor
Yes, ma'am.
And you actually have a no bond hold on,
We're
by
gonna let
Judge
her know.
Hurley for a trespass other structure. He issued it July 12th, 2018. Court does find probable cause for the arrest for the capias. What say you, Mr. Linder?
Okay, Your Honor, Mr. Cunningham has multiple cases, both felony and misdemeanor, in front of Judge Merrigan in Veterans Court. He had a no bond capias, and on July 9th, Judge Merrigan on a separate case withdrew the capias, RORing him. Based on Judge Merrigan taking that action, I believe the most appropriate action to take on this case would be to ROR him, transfer the case to Judge Merrigan's Veterans Court. He has, on his other cases, he has a status conference scheduled for July 23rd. So I would ask the court to...
Okay, so you want me to ROR him on this,
Yes.
and what date is he was advised of?
He has a status conference on his other cases, July 23rd at 1:30 before Judge Merrigan. So I'd ask that this case be transferred to Division MVC. And then there's one other matter I have to make the court aware of.
Okay, no problem. Okay, 7:23 at 1:30 before Judge Merrigan. Let me get his courtroom number. What is he in, the north wing? Oh, it is? Perfect.
Okay.
What is it? 6870.
That's what he told me. He knew about that court date.
Okay, well, that's good.
All
All right, so what else would you like to tell me?
Okay, Your Honor, Mr. Cunningham has another trespass case in front of Judge Hurley that is actually scheduled for arraignment at 1:30. I don't know if the court may want to contact Judge Hurley after the docket to advise him, and maybe Judge Hurley could transfer that case to Judge Merrigan.
All right, so
and schedule it for...
let me just get Michelle down here and she'll do it. Can you come down? I need your help. Thanks. All right, so I'll just hold on to this for one moment. Okay. All right, so sir, you have another case that they're going to be transferring there, okay?
So that case now is also going to go to Judge Merrigan's, okay? So you'll deal with one judge.
Would you like me to sign an order in that case as well, Madam Clerk? Okay, we're going to do it in that other case. What's the case number?
18-1143 MM28.
That's the one for,
It's a trespass. It's scheduled arraignment this afternoon in front of Judge Hurley.
all right, so I'll have Michelle call Marge. All right, so I'll tell you what, Madam Clerk, here's the case number when Michelle comes down.
Your Honor, I'm sorry. I looked at the wrong date. Thank you. It's actually, he's scheduled for arraignment July 19th at 1:30.
All right, well, we'll tell him anyway.
Yeah, I just wanted to...
Tomorrow.
Yes, but
So
when
wait a
Michelle
minute.
advises Judge Hurley...
What's the court date today? It was tomorrow. Hold on. That one we didn't know about.
Okay.
Obviously, the state has no objection to Judge Hurley transferring it prior to the arraignment.
Okay, beautiful. So that is going to go on.
Both of them.
Yeah. Mm-hmm.
Okay.
So
All right, so he just has to go to court that one day, okay? Thank you, sir.
good luck, sir.
Hold that paperwork for Michelle. I put the case number, Madam Clerk, so she can call Judge Hurley's office. Okay, one moment, sir. All right, Fidel Alejandro Rivas, please.
Mr. Rivas is here, present, Judge, I may.
Okay, Mr. Rivas, you have battery, cause bodily harm, $1,000 bond. Counts 2, 3, and 4 don't require a bond, which is basically an ROR. Disorderly intox, public place, causes disturbance, trespass, failure to leave property upon order by owner. And count 4, failure to report to, or, can't read this, failure to report to, or OBST. What does this mean? Headmaster?
I was kind of
Harbor
wondering
master.
about that myself.
Resisting
Resisting an
officer
officer
or
or
obstruct
obstructing a
harbor
harbor
master.
master.
Your Honor, I'd refer the court to the probable cause affidavit. It's, one moment, Your Honor. I believe it should be
Refusing to leave a
resisting an
business.
I believe it should be resisting an officer without violence.
Okay. All right, so bond set at $1,000. Court does find probable cause. Count 4, the court's going to treat as PC for resisting without violence. No bond attached to that. Stay for a couple minutes.
Nothing to add from the defense, Judge, just we'd be requesting a photo order.
Okay, we'll give you a photo order. It's his address, 1550. It has Merifian, Merifian Avenue, number 3, Miami Beach.
That is his address, Judge.
All right, thank you. Good luck to you, sir. Next one is Jordan Rosales.
Did you order no victim contact on that, please?
Oh, hold on, sir. Bring him back. No, I did not. Okay, Mr. Rivas, we are going to order no victim contact, direct or indirect, with the alleged victim in the case with the initials AYA. Do you understand what no victim contact, direct or indirect means, sir? If you don't, I'll be more than happy to explain it to you.
He doesn't know who the victim is.
Well,
all right.
Your Honor, I was also going to be asking for no return to the Amsterdam Bar and Restaurant, and the alleged victim's the owner, so that should, as long as he doesn't go by there, it should probably take care of both issues.
Okay, and no return to where?
Amsterdam Bar and Restaurant.
Okay, sir, you hear that? No return to the Amsterdam Bar and Restaurant. If you go back there, you're going to be arrested. Do you understand?
Yes.
All right, thank you very much. Good luck to you. Jordan Rosales.
Mr. Rosales, come on up, please.
Okay, Mr. Rosales, you have prostitution, lewdness, offer, commit, engage, first offense. Court does find probable cause. Bond set at $300. What say you, Mr. Romero?
Nothing to request at this time, Judge.
All right, it says address 15200 Northwest 29th Ave, Miami Gardens.
Yes, that is, Judge.
All right, thank you very much, sir. Good luck to you. Christopher Allen Jinks, Jinks.
Mr. Jinks, come on up, please.
Okay, Mr. Jinks, you have a no-show status hearing. You failed to appear in May 2017. You have a suspended driver's license. Bond set at $250. What say you, Mr. Romero?
Nothing to add at this time, Judge.
All right, sir, your address is 2703 Northwest 193rd Terrace, Miami Gardens.
That's your address, sir? Yes? Yes.
All right, let me change it because they have a different address on here.
It's 2783, Judge.
2783?
Yes.
Why doesn't he just tell me? It's easier for me.
Okay, say the Judge.
2783 Northwest 193rd Terrace.
And where is that, sir?
Miami Garden.
zip code, if you know it.
33056.
Okay, thank you very much. Your address is going to be updated in this case, okay?
Correct, sir.
Thank you. Okay, I'm signing a photo order for this gentleman. Okay, John Mokia.
He's here present. This is a municipal ordinance case, Judge.
All right, sir. You have the charge of trespassing. Bond set at $25. Court does find probable cause. Can you afford to pay the bond, sir?
Excuse me now? I didn't.
Can you afford to pay the bond?
No. Can we resolve this today?
Okay, this is how this works. We do have an attorney, Mr. Shate, that can represent you. If you want him to represent you, if you do, I'm going to ROR you and appoint his office. If you want to represent yourself, you have to waive your right to an attorney, because if you can't afford an attorney, one will be appointed. If you want, I can ROR you. I don't have a problem with that. I can tell you in both cases, I am going to tell you not to go back to 600 Brainy Avenue in Pompano Beach. Do you understand?
Yes, I understand.
You know what happens if you go back there, right?
Yes, Your Honor.
All right, so you want to waive your right to an attorney, or you want me to ROR you and you can fight your case?
I would rather just resolve this.
All right, you understand that you're going to have an adjudication, a conviction on your record.
Okay, can I do no contest?
You can do no contest, but this is going to be a criminal conviction because I'm going to adjudicate you guilty.
Okay, Your Honor.
All right. State, let me ask you this. Do you know what his priors are?
Not off here, but I can look them up.
You know what? I'll tell you what. I'm not going to resolve this case today, sir. I'm going to ROR you. I'm going to appoint Attorney Stephen Shate. The reason why I'm not resolving it, it says you've been trespassed, warrant, arrested on many occasions, but continue to defy the City of Pompano Beach Municipal Ordinance. So let me ask you, sir, is there any place you can get mail for your court notice?
No, well, I have one open.
Don't talk about any of your cases. This is the question. Do you have any place where you can get notice of your court date? Do you have an address of a friend, family member, or anybody?
No.
All right. All right, Mr. Romero, I'm going to ask you to provide Mr. Shate's telephone number to Mr. Mokia here. It's your responsibility, sir, to call Mr. Shate and find out when your court date is. You can also go to the clerk of the court website, browardclerk.org. You can go to a public library, okay? And you can put in your name and it'll tell you when your court date is.
Okay, no problem.
Do you have a phone number Mr. Shate can reach you?
Yes.
What is it, sir?
954.
Okay.
628. 6117.
All right, sir. Get in touch with Mr. Shate. Call him when you get out, okay?
Thank you, Your Honor.
You're welcome. Good luck to you. All right, tell Mr. Shate, put Pompano on the bottom, PNP, so he knows. All right, next one is Anthony Joseph.
He's been transported downtown to his division, Your Honor.
Okay, so he has ad charges. All right, so let's reset him for PM today. Maybe you can get a hold of him. If you call downstairs, ask him, tell him we want to put him on the docket for 1 p.m. this afternoon. All right, Zachary Rapp, please.
All right, Your Honor.
Okay. Mr. Rapp, good afternoon, or good morning, rather, sir. You have 2 ad charges dealing in stolen property, $3,500 bond, grand theft of a firearm. The court does find probable cause. State any special conditions, and then we'll hear from the defense.
Just request no possession of any firearms, weapons, ammunition until further order.
Okay, sir, no possession of any firearms, ammunition, or weapons till further order of the court. What say you, Mr. Reedy?
Mr. Rapp has a no bond hold on the violation of probation. Unfortunately, I don't have a court date for him, but I'd ask the court to leave the bonds in place in light of that.
All right, so $999 on count 7. We'll leave $3,500 on count 6. Thank you, sir. Good luck to you, okay? No possession of any firearms, ammunition, or weapons. You can use Mr. Reedy's phone if you have to. Or their phone. I don't... Either one. All right, Gabriel O. Young, please. Y-O-U-N-G.
Counsel, Your Honor.
All right, Mr. Young.
Your Honor, he's in courtroom 6780 this morning.
Gabriel Young?
Yes, ma'am.
Where is he? Courtroom what?
6780.
Okay, we're going to reset him. Here you go, Miss Bailiff. Thank you.
You
Rickson.
Downing here? Okay.
Go ahead.
I have Downing here for Paul Ryan.
Okay, what's his name?
Downing.
Downing.
He was at the wrap on page.
What page is he?
12, Your Honor.
He's towards the end of the document.
First name?
James. James.
And Judge, may we approach?
Sure. Okay, are you James? Is it Jamie or James?
James.
James Antonio Downing?
Yes.
All right, sir. We have the Public Defender's Office who's here representing you. In the courtroom with me, Mr. Reedy. This is a change of charge from robbery, no firearm, to robbery with a firearm. Is that correct, State?
In a way, Your Honor, as you can see, I provided the court with the original findings.
Mm-hmm.
And Judge Dennis Bailey found proof evident of presumption great for robbery with a firearm or deadly weapon. He wrote in the with on the findings.
Okay.
And for, so I'd ask the court to adopt Judge Bailey's previous finding. And count 4 is an add charge. I'd be requesting $2,500.
Well, we don't have that on my page. I only have a charge 1. I don't have a 4. And it actually says 3 on here, possession of a firearm by a convicted felon.
Okay, that's the charge on the information. It's we're talking about the same thing. As long as you have possession of firearm.
Okay, I'm going to add, Sheila. I'm going to add possession of firearm by a convicted felon on my sheet. What number would you like me to assign it since the robbery is a 1? Huh?
It should be count 1 and 4.
Okay, so the possession of a firearm by a convicted felon. All right, and what are you requesting on count 4 for a bond?
$5,000, Your Honor. He's just to also advise the court. He's been qualified as career criminal. The case has been transferred to Judge Bober's career criminal division. Or repeat offender.
Okay, what say you, Mr. Reedy?
Your Honor, Mr. Downing currently has a no bond hold as well, so he's going to have to go in front of Judge Bober to resolve that, no matter what bond the court sets today.
Okay, so the court's going to set bond at $5,000 on count 1. Sir, the court, I have reviewed the probable cause affidavit filed in your case, and I find probable cause. Further find the proof of guilt to be evident or the presumption great. Therefore, you're going to be held without bond until further order of the court. This order is without prejudice, sir, for you to file a motion to set bond, and this is the robbery firearm charge. With your assigned division judge, who is Judge Bober now, under the case of State v. Arthur on count 4, possession of firearm by a convicted felon. Court's going to set bond at $5,000. The court further adopts Judge Bailey's prior ruling, and this is Judge Dennis Bailey. All right, thank you very much, sir. Good luck to you. Madam Clerk, if you could make sure that this is attached at the bottom. You're welcome. Okay, Rickson Emmanuel. Rickson Emmanuel.
He's approaching, Judge. He's here at Maine.
Okay, thank you very much.
If I could be heard before the court makes a finding.
All right, Mr. Rickson Emmanuel, you have, looks like count 6 or count 8, aggravated assault by a person detained in a prison or jail. What say you, State?
Reviewing the probable cause affidavit, it appears it was the deputy's intent to charge him with assault, not aggravated assault.
Okay, so PC, what say you, defense?
I believe that would be correct, Judge. Unfortunately, Mr. Emanuel has no bond holds, currently keeping him in custody, but I would ask the court to set a bond commensurate with the assault charge.
Less than $1,000 bond.
Okay, so the court finds probable cause per the state and the defense for assault by a person detained in a prison or jail. Any objection to the $1,000 bond? Is that what you said?
Yes, Judge.
Considering no bond hold, Judge, I'm not going to have an objection for
Okay,
$1,000
$999. Thank you. Good luck to you, sir. Next one, Patrick Beauplan, please.
Conti?
Okay, Mr. Beauplan, how are you, sir?
I'm right, Your Honor.
All right, you have some ad charges. Possession of cathinones. What's SUBST?
Substituted.
Substituted cathinone, sir. $1,000 bond. Court does find probable cause for the capias. This is count 6. What say you, defense?
Your Honor, I can advise the court he has a no bond out-of-county hold at a date for a VOP.
Okay.
I was just going to be requesting that the $1,000 bond be kept in place.
Okay. Mr. Reedy, he has a $1,000 bond. This is a capias felony. He has a no bond hold.
Yes, Judge.
$999.
Yes, that'd be fine, Judge.
Thank
Yes,
you.
Judge, resolved.
Thank you, sir. Good luck to you.
Thank you, Your Honor.
All right, Jamalise Jermaine Shaw. Jamalise Jermaine Shaw, please. And then after him is William Patrick Mellon.
Jermaine Shaw bonded, Judge.
Okay, what about William Patrick Mellon, please?
Mr. Mellon, come on up, please.
Okay, Mr. Mellon, you have burglary, unoccupied structure, unarmed, $10,000 bond. You have a county, says sentence felony, no bond hold, not for magistrate. That's in case number 17-10192, CF10A from Judge Garcia Wood. Says the SAP program. It shows suspended driver's license, no bond hold. That's not on here either.
That's part, yeah.
Okay, it's fine, as long as we don't have to worry about, I'm just bringing it to your attention. All right. All right, so the court does find probable cause. What say you, defense?
Judge, I understand he's right now serving a county sentence. I believe he was sentenced yesterday to 270 days Broward County Jail, mitigated by the SAP program to 210 days.
Yeah, it says a 30-day SAP program.
So therefore, Judge, no matter what, he's not going to be getting out because he has to serve his county jail sentence. So I understand count 1 is a $10,000 bond. It is a third-degree felony. I would say it's just a little bit too much, I believe, for a third-degree felony. But like I said, he's not going to be getting out until.
All right, so are you telling me to leave the bond in place?
I don't know if Your Honor would consider it $999.
Your Honor, I'm asking the court keep the $10,000 bond in place. He's going to be in custody a minimum 30 days, more than enough time for his attorney to get him in front of Judge Garcia Wood. He was out on a grand theft when he allegedly committed this burglary structure. He's gone to prison in the past for strong arm robbery where he violated probation.
And for the record, Judge, his sentence is not going to mitigate up to 30 days.
I saw that.
It's going to go down to 210.
And Your Honor, just to have an idea, I don't know if this, as you saw, he was just sentenced yesterday.
Okay, so, Mr. Reedy, maybe you can send a note to the public defender. They can calendar to set a motion. Thank you, sir. Good luck to you. Neil Paul, please. Neil Paul. Okay, Mr. Paul, you have possession with intent to purchase barbiturate, $1,000 bond. Count 2 is corrupt by public threat or threat a public servant or family. No bond attached. Well, it's actually HG, so we'll have to talk about bonds. Solicit another for prostitution, lewdness, first offense, $500 bond. Counts 4 and 5 are capious traffics. One is for expired driver's license, more than 6 months, $250 bond, and failure to register a vehicle, $50 bond. Court does find probable cause. What say you, defense?
Judge, maybe I'm missing a probable cause affidavit. I don't know if there's a second report, but the report that I have does not mention anything about any corruption by threat.
Mm-hmm.
Your Honor, I agree. I would ask for 24 hours on that count, but I don't have an objection with the court.
Okay, so
setting a
24
bond
hours, no probable cause.
And Your Honor, if I could address one other thing.
Hold on, so I'll say for 7/19/18.
It also appears that count 1 is a misdemeanor possession of marijuana.
All right, let's just start one thing at a time. So that's count 3. All right, count 1, go ahead.
It appears what was found in Mr. Paul's pocket allegedly was less than 10 grams of marijuana. I don't see anything about possession with intent to purchase barbiturates. I don't see any mention of barbiturates in this report at all.
And Your Honor, I would direct the court and Mr. Reedy's attention. That's just on the booking sheet. If you look at the PC affidavit, the officer charged him with possession with intent cannabis.
Okay, so we're going to change count 1, possession of cannabis under 20 grams?
Well, Your Honor, I don't necessarily agree that it's simple possession. He was in possession of 9.7 grams in 10 separate Ziploc baggies. I don't necessarily believe that it's
All right, well, the
purchased.
officer charged him. Mr. Reedy has a valid point. It says possession with intent to purchase barbiturate.
That's not, I understand, but that's not what he was charged with by the officer. If you look at the PC affidavit, Your Honor, it just says cannabis.
Well, it says on the booking report.
But the booking report wasn't done by the officer. That was done by BSO at the jail.
Okay, it's possession with intent to.
Sell or distribute
It
cannabis.
doesn't have that on mine, but I understand it says cannabis. So that's an F3?
Yes.
Sell, manufacture, or deliver. Okay, and F3. All right, do you object to that? Mr. Reedy?
Yes, Judge?
I do that too. All right,
Well, I'd be
possession of cannabis with intent to sell, manufacture, or deliver, it's an F3 on count 1. Does say it on the PC.
Is the state asking for 24 hours to perfect?
They're asking for that on 3.
On 2.
On 2.
I'm sorry, on 2. Okay. All right, so what are you asking for? So on 2.
I'd ask you to ROR Mr. Neal on count 2.
Okay, at this point, I'm not going to just straight ROR him. I'm giving them 24 hours, so let's talk about something reasonable.
Your Honor, I'd be requesting a $1,000 bond without prejudice, depending on what information I provide in 24 hours, if any.
Okay, I find that reasonable. All right, so what do you want to do with the other bonds? Because it's 1,000, 1,000, 500, 25, 2750, 2780.
You can leave.
All right, so right now, 2850, okay?
Your Honor, Alejandro Vargas here with Mr. Paul at the jail. Just so I have everything cleared up, that's 1,000 count 1, 1,000 count 2. Then the other bonds remain the same. The total is
2850.
$2,800.
Well, it's 28.
The total bond with the Capies is $2,800.
That's way too much for me.
750, yep, 2,800. We'll see you tomorrow, sir. Thank you. Dylan Adams, please. Dylan Adams.
Good morning.
Morning. Okay, Mr. Adams, you have burglary, unoccupied conveyance, unarmed. We need to talk about bond. Count 2 is possession of cannabis, 20 grams or less. Count 3 is drug paraphernalia, possess and or use. Counts 2 and 3 is basically an ROR. There's no bond attached to it. The court does find probable cause. What say you state on count 1?
Excuse me, Your Honor. I'd be requesting a $5,000 bond on the burglary conveyance. He's been to state prison out of Okeechobee County, 2010. 3 separate charges of sale or delivery of controlled substance within 1,000 feet of his school. He was sentenced to a year, 2 months state prison, released in 2013. He has 4 prior felony convictions, 8 prior misdemeanor convictions, 2 prior failures to appear.
Lawyer, please. Release 2013. Release 2013.
Okay, we can hear you, so.
Yes, Judge. Thank you. Mr. Adams, the last I heard from the state was that he was released in 2013. He does reside in Okeechobee. He's lived there his whole life with his family. He does have somebody that will post a bond. He does presently work. However, the $5,000 is a bit more than he's presently able to post. Would the court consider lowering it to $2,500?
All right. Is your address 425 West Village Street, Okeechobee?
Yes, ma'am.
All right, this is what the court will do. The court will set bond at $3,000 on count 1. The other 2 don't require it. Thank you, sir. Good luck to you.
Thank you, Judge.
You're welcome. Don't fail to show up for court because you'll have a no bond hold.
Yes, ma'am. What's my court date, ma'am?
I don't know, and you can look online if you don't get a notice or contact the public defender's office. You can go to browardclerk.org and do a search, okay?
Yes, ma'am. Thank you.
You're welcome. Radek Zionov.
He posted bond.
Bonded, Judge.
I'm sure I mispronounced this gentleman's name. Stephen Lee Batchelder.
He bonded, Your Honor.
Alphonse Metlis.
Yes, here, ma'am.
And, Your Honor, if I could be heard before the court makes
Sure.
a finding.
All right, go ahead. I'll let you go first.
Thank you, Your Honor. This should be 2 counts of attempted burglary conveyance. I think what happened, the officer on the PC affidavit put count 1 and count 2 for the 2 burglaries. And when he was booked, they got added together to form 3 counts.
Okay, I'm sorry. So 1 and 2 are attempts.
Yes.
And what about 3 and 4?
Well, there shouldn't be count 3. It should be no PC.
Okay, no PC. Sure, the defense doesn't have an objection to that.
I suspect.
In fact, I was going to make that exact same argument.
Okay. I don't know why the one has a bond for $25. I don't even know what that is on 4. Do you see that?
It's a trespass.
It's trespass, Your Honor.
Oh, okay, I see. So count 3, you're saying there's no PC. What about count 4?
Well, I don't have an objection to PC for the trespass.
Okay, I'm asking
I know,
you. You're
I'm
saying
saying-
no PC for count 3
Yeah,
or 3 and 4?
No, just 3 because they
Okay, I misunderstood.
accidentally
I
added
thought
an
you
extra
said
burglar.
4.
No.
Okay. All right, so the court does find probable cause on an attempt on count 1 and 2, and no PC per state on count 3, so that'll be an ROR, and the trespass property, not a structure or conveyance, bond set at $25. So what are you asking for on counts 1 and 2, state?
1 minute, Judge.
Sir, while he's doing that, let me verify your address. 3820 Northwest 41st Street, Lauderdale Lakes?
Yes.
All right.
Yeah.
Your Honor, I'm going to be requesting bonds in the amount of $5,000 per each count. I am concerned he was arrested May 6th for trespassing at 4201 Northwest 34th Street in Lauderdale Lakes. This essentially the same location where he was arrested here.
Was he told not to go back there?
He was, but what's even more concerning is he was just seen by security, in that case, wandering around the parking lot. In this case, he's allegedly breaking into cars in the parking lot at that same location, or attempting to.
Okay. All right, what say you?
Your Honor, Mr. Medalist has lived in Florida for approximately 15 years. He resides in Lauderdale Lakes with his mother at the address that he just verified with the court. He is presently unemployed. He is trying to go back to his previous job that he had washing cars. His mother is presently a housekeeper. The bonds set in the amount, that the state is requesting of $5,000 as to each count are excessive given his current situation. What Mr. Medalist would be able to post, as he relayed to me, would be somewhere in the amount of $100. So what we would ask the court to do is to set bonds as to count 1 and 2 as $500 each, ROR him on count 4, and attach some sort of pretrial release if the court would deem that appropriate.
All right, this is what the court's going to do. 1 and 2 is 500 each. 3 and 4 are ROR. I'm going to do a GPS level 2. No return to the St. Croix apartment, sir. That's on Northwest 34th Street in Lauderdale Lakes. You understand? If you go back there, you're going to violate your conditions of your pretrial. You'll probably be held no bond. Do you understand that?
Do you understand that?
All right. What's the address for them to verify where you're going to be living, sir?
What's your address that you live at?
3820.
Say it loud.
3820 Northwest 41st Street.
Okay, but let me ask you this, sir. Where, is there a phone number for who you're going to be living with? You think you said your mother?
Yeah.
What's her phone number?
561.
Say it louder.
561. 561. 8.
You don't remember?
Nah, I don't remember.
Is it in your property?
Is it in your phone? Do you have a phone and property?
No.
What's your mother's name?
Joyceline.
Jocelyn?
Yeah.
What's her last name? Same last name?
No, it's 561-609-8526.
561-609-8526, Judge.
Spell your mother's first and last name.
D-O-R-Z-I-L-E-I-N-E.
And what's your mother's first name?
That is her first name, Judge.
Joyceline Metellus.
Metellus. Same last name. Her first name is Dorzaline. D-O-R-Z-I-L-E-I-N-E. Same last name, Your Honor.
Okay, Miss Patrice, you need the address. Okay, thank you, sir. All right, so I'll grant your request 500 on each. ROR on 3 and 4, no return to LaCroix Apartments. GPS level 2. Do you need the mother's information again? Miss Patrice, you got it? All right, thank you very much, sir. Good luck to you. Tell your mom, sir. When you talk to your mother, tell her pretrial services is going to be calling her to confirm you can live there. Otherwise, you're not getting out, okay? Thank you. All right, David Aiden Ramsden, please.
Medical reset.
All right, sorry about that. Dexter Roswell Dvorak.
Main Judge.
Okay. Mr. Dvorak, you have drug paraphernalia, possess and or use, and tamper with or fabricate physical evidence. There's no bond on 1. Count 2 is $1,000. Court does find probable cause. What say you, defense?
Your Honor, Mr. DeVore has lived in South Florida all his life. He does currently reside in Hollywood with a roommate.
My mom, my roommate, my family.
Several roommates, Judge. He receives disability So the $1,000 bond is excessive at the moment. His disability check is spoken for. He presently is unable to post any bond, as is anybody that he resides with. We would ask the court to consider pretrial release.
Any objection, State?
Yes, Your Honor. First, let me just note, and the courts have been clear on this, that a bond is not excessive simply because it's above an amount a defendant claims he can afford. Also, I would note, Your Honor, he just pled out charges of theft, resisting without violence, and he was qualified as a habitual offender on that case. And possession of PVP, he violated his probation on June 12th of this year, was sentenced to 364 days in county jail, and was just released June 12th of this year.
Okay, is your address 514 Northwest 12th Ave? Can you get me those,
Yes, ma'am.
Find it for me on Devereaux's. 514 Northwest 12th Ave, apartment A, Fort Lauderdale?
Yes, ma'am.
Okay, give me one moment, sir. We'll be right back. Yes. Okay. All right, if he's going to North Broward, then we'll just have North Broward. We'll reset it. That's fine. If he's not, then we'll just reset him. But the one that's still upstairs, can they bring him here? I mean, bring him to the main jail at 1 o'clock to be magistrated. Hold on a moment, sir, okay? Oh, okay. Did you find out, Michelle?
Find out the numbers?
Yeah, which is the one that you have for Maine? Do you have? Okay, did you call 5934? Okay, maybe that's a. Okay, well, if you can't get an answer there. Okay. Okay, so Mr. Vargas, what say you? On Mr. Devereaux, what are you asking for again?
Judge, I asked if the court would consider placing Mr. Devereaux on
pretrial release.
Trial.
I have to tell you, I'm looking at this risk assessment, and he has a high score. I mean, the bar is all the way across.
Are you arrested?
Pardon?
Say something. Okay, the last previous time I was
Sir,
locked up was because I'm...
Sir, you know
No, I
what?
just
You
wanna
have an
say this.
attorney next to you. You have the right to remain silent. Anything you say can and will be used against you. Why don't you talk to your attorney and let him communicate it to me? If you want to talk to me, I'll allow you. I'm just telling you of your rights.
We can proceed, Your Honor.
I'm sorry, say that again?
We can proceed.
Okay.
And, Your Honor, and I'm sure this is probably considered in the risk assessment, he was on pretrial in 2015.
No, it isn't.
What's it?
It's, I don't have it on here that he was in the risk assessment, but
No,
that's fine.
It doesn't mention it specifically, but I'm sure it was taken into consideration when he was
Sure.
given his score. In 2015, he was on pretrial and was picked up on a warrant for violating his pretrial. He was on a felony case.
Okay, what was he on pretrial for and what did he violate with?
I'd have to check the basis for the violation, but it was the possession of PvP and theft case that he just got out of jail last month on for violating his probation. And
I'm inclined
He
to,
was-
go ahead.
he didn't report within 24 hours of his release to pretrial.
Okay, well, I'm gonna tell you what, I'm gonna give him a chance. It says he just ate a pill. But I'll tell you this, sir, if you don't report to pretrial services,
Yes, ma'am, I hear you.
they're gonna give you a map. You have to report within 24 hours. So you're gonna get out today. That means if you get out before 3 p.m., you go over there. But if you get out after 3 p.m., because they close at 4, but you have to get there a little bit early. If you get out after 3 o'clock, then you're allowed, you go there tomorrow by 12 noon. It's across the street from the old courthouse, okay? Can you hand them a map in front of me? If you don't go there, what do you think's gonna happen?
I'll be picked up.
And what do you think your bond's gonna be?
Probably no bond or something like that.
Okay, so if you want to be in jail on no bond hold, then it's up to you. 514 Northwest 12th Ave, Apartment A, Fort Lauderdale?
Yes, ma'am.
All right, thank you very much. Good luck to you. Odell Whitefield. That's a medical reset from yesterday, so.
That's right, Your Honor.
Is he here?
Yes, ma'am.
Okay. All right, good morning, Mr. Whitfield. You have possession of controlled substance without,
Don't say anything, Mr. Whitfield. Listen to the judge.
all right, Mr. Whitfield, you have possession of controlled substance without a prescription, $1,000 bond. Count 2 is trespass, failure to leave property upon order by owner. There's no bond attached to that. The court does find probable cause. What say you, Mr. Reedy?
Judge, I'm going to ask you to ROR Mr. Whitfield. The drug that he was in possession of, which is hydrochlorothiazide, is a blood pressure medication. And he does have high blood pressure. He had a legitimate reason for having it. Technically, I suppose he didn't have the prescription with him.
I have no objection to an ROR.
Thank you, Judge.
Okay, so ROR, but I am going to order no return to the Whole Foods, or do we need to not do that, State?
I'm sorry. Yes,
Hold on, I'm speaking to the State, sir. Give me a moment.
Yeah, that's fine since you already have a trespass on him there to begin with.
So no return to the Whole Foods?
Yes, please.
All right, sir, one of the conditions of your release is that you're not to return to the Whole Foods located at 2411 North Federal Highway, Pompano Beach. If you go back there, sir, you're going to get arrested. So don't go back there until further order of the court, okay?
Yes, ma'am.
Judge, I'd also like to update his address.
Yeah, I was just going to ask him.
It's 915
Hold on one second. Okay, 915.
Middle River Drive, Fort Lauderdale.
Hold on. Middle River Drive, no apartment number?
Is there an apartment number, Mr. Whitfield?
So Suite 401.
What is it?
401, Suite 401.
401?
Yes.
Okay.
Fort Lauderdale?
Yes,
Yes,
Judge.
33304, Fort Lauderdale.
right, Odell, it's up to you to keep track of your court dates to come back to court. Okay.
Sir, you can go to browardclerk.org and put in your name and also find out your court date. You can also call the public defender's office, which you should do within the next week, okay?
Okay.
All right, thank you, sir. Good luck to you.
Thank you.
All right. One moment, we're gonna.
Judge.
Okay, Mr. Skinner, you have possession of a weapon or ammo by a convicted Florida felon. We need to talk about bond. Counts 2 and 3, sir, don't require a bond. They're basically RORs, resisting an officer or obstructing without violence, and obstruction of highway. Court does find probable cause. What are you requesting as far as count 1 and any other special conditions state?
Your Honor, I need a moment.
Sure.
Your Honor, if you want to go ahead and inquire the defense.
All right, so what are you requesting as far as bond on count 1, the possession of weapon or ammo by a convicted Florida felon? And it says your client is at large, by the way.
I do understand that, Your Honor. That's the information that I have as well. Mr. Skinner has a difficult time most days, to put it that way. He doesn't have any family in South Florida. He presently, as the court noted, is at large. He cannot afford any bond himself. Have been provided with a contact that potentially may be interested to know he's in custody, but he doubts would be available to post a bond on his behalf. Honestly, any amount that is set by the court, Mr. Skinner would find himself in a position that he'd be unable to post it. So it would be equal to a no bond hold. Given the light of that information, I would request the court to consider placing Mr. Skinner on pretrial supervision. Additionally, Judge, while I have the court's attention, we would be requesting a photo order.
Okay, the court will grant your request, sir, for a photo order. State?
Your Honor, I'm going to be requesting a $2,500 bond. He's gone to prison in the past out of Dade County for carjacking with a firearm or deadly weapon. As you can see on his booking sheet, he's used aliases in the past. Has given false dates of birth, false social security number in the past.
You think I had to use a scanner?
So I do have concerns about his future appearance in court.
Okay, this is what the
If I may respond to that.
Sure, absolutely.
I do understand the state's concerns for his future appearance in court. I don't think that would necessarily, in and of itself, without more information as to when his last release from incarceration was for any alleged crime of violence, that doesn't necessarily safeguard the community from any real immediate concerns as to public safety. So once again, I would ask the court to consider pretrial release.
Your Honor, my concern for public safety is as a convicted felon, he's out walking around with a double-bladed knife when he's not supposed to be in possession of any weapons.
Judge, he's also, again, at large, so that is one concern of Mr. Skinner's to be able to have some sort of means of protection. I'm not justifying the possession of the weapon, merely explaining the situation.
And in his statement, he did say that that is why he has the knife, is to protect himself.
My concern is he's not going to show up, and I'm looking at this risk assessment. It says medium. but, I mean, they had to use a fingerprint scanner. He had choice words more than one occasion to the officer, was completely not cooperating at all. And I just don't have confidence that he's gonna show up to court and that he's gonna comply with standard pretrial. So tell me your thoughts, Mr. Reedy or Mr. Vargas.
I defer to Mr. Vargas.
Your Honor, I do understand the court's concerns. Speaking with Mr. Skinner, I don't get any impression of a person that's going to willfully or intentionally leave anything hanging over his head, so to speak.
Do you have any failures to appear, State?
I'll check, Your Honor.
Does he have any money in his property?
Do you have any money? I got a couple of
What does he have?
He said he had a couple of dollars, Judge, but I ain't got no money.
What's a couple dollars?
About $20, he says, Judge. So maybe 10. Maybe 10.
How's he gonna look up his court notices?
You can come to the public defender's office.
He can go to the public library, go to
You can go to the library, Judge, come
browardclerk.org.
to the courthouse.
Your Honor.
Yes, ma'am.
I'm asking pretrial. It's not showing in my system, so I'm asking pretrial to check about prior failures to appear. But while she's looking, this would be his. I saw some other things. This would be his third arrest since June 12th of this year. The prior two were for resisting without violence. He also has a prior for violation of pretrial release conditions, that being a no contact order. So he has shown that he doesn't
He
follow.
violated a no contact order when?
That was in 2015.
Contact.
Do you have any mailing address at all, sir?
No, ma'am. I'm homeless.
Okay, he can go to the Central Receiving Center. Have you guys been there?
We were there yesterday.
Oh, okay.
Yes, I was gonna suggest that.
Yes, I was.
But they can't use that as a mailing address.
There's Mr. Romero.
Mr. Romero and I had quite a wonderful
We
time.
actually went there and we were impressed, Judge.
I thought
We
you
were
would be.
impressed.
I was too.
And one thing we did find out, I think Mr. Reedy was going to go ahead and talk about that, is though they can't use that location as a mailing address, when they go there, they try and do wraparound services, and most the situations that they encounter are people that are in need of housing. And when they refer them to certain locations for services, then they follow up, and at that time they can actually, they said they would look in the computer system and advise that individual of their future court date. So, I mean,
Well, that's pretty neat.
Goes out. So there's another way of a person being informed as far as when his future court date is going to be.
All right, does he want to go to the Central Receiving Center and get help?
Understand? Yes. Yes.
I
Okay.
can talk to him about everything else.
Smart decision, I think.
It is.
All right, this is what I'm gonna do. I'm gonna ROR you, sir, but you're gonna have to show up for pretrial services. But here's the problem. How do I get him over to the Central Receiving Center?
I'll come pick him up, Judge.
No, I know, but did they do it from the main jail?
Yes, ma'am. Twice a day, 9 a.m.
No,
9 p.m.
I'm asking Miss Patrice, how we can get him interviewed at the main jail. All right, so we'll do it by 9 a.m. tomorrow morning. Here's the thing, sir. You're going to have to call in I'm gonna have you call in actually 3 times a week.
Yes, ma'am.
If you don't call in, then you're gonna be violated and you're gonna have a no bond hold.
Yes, ma'am.
Do you understand?
Yes, ma'am.
And the only time that you're gonna have to report in person is when you, have a court date. Then you'll have to go over to the courthouse, across the street, and go there. There's a bunch of terms and conditions. I'll put on here, standard pretrial supervision will interview, and one of the conditions is that you go to the central receiving center, okay?
Yes, ma'am.
And we'll have you going there 7/19/18 at 9 a.m. And you agree to that, right, sir?
Yes, ma'am.
All right, you'll be transported there. Okay?
Yes, ma'am.
All right, keep in touch with your court date. Don't let me see you back here. You'll have a no bond hold. It's up to you. Thank you. Okay, Julio Ramos.
I believe that's a medical loan.
Okay. Terrence Dagrin.
Medical is also.
Okay. Christopher Seymour.
And Your Honor, may we approach?
Hey, Judge.
Sure.
And Your Honor, we'll bring up all the paperwork for the COCs at one time. They're in order.
Okay. Seymour?
Yeah.
Yes. No problem. So let's reset them this afternoon. Yeah, but by the time we get done today, it'll be 3 o'clock. I'm just saying, he might be back to Conti. Not yet. No, I know, but by the time he gets back there, they're pretty fast about bringing him back. Just reset them for the afternoon. If we have to, we'll set them the next day. Thank you. All right, Christopher Lee Seymour, sir, you have change of charge. Resisting an officer or obstructing with violence, possession of firearm by a convicted Florida felon, and burglary damage to a structure or dwelling. Court does find probable cause. Anybody wish to be heard?
Your Honor, I'm asking that the bond on the down file from the
Well, it's actually an add to count 2. I'm sorry.
I'm asking for the down file from the aggravated battery to the resisting of violence be set at 1,000.
On count 1?
Yes.
Okay.
The firearm for a felon was a lateral change to possession of a weapon or firearm. It was originally 1,000. I'm asking that be kept at 1,000.
Okay.
The add charge, burglary of a damage to a structure, I'm requesting a $5,000 bond. He's also currently being held no bond on an armed burglary that was filed as presented.
Okay. All right, so 1,000, 1,000, 5,000.
No bond.
Yes.
So we can't set it right now.
All right, so he has a no bond hold.
Understood, Your Honor.
All right, so $999 on count 1, same for count 3. For the possession of firearm by a convicted Florida felon in count 8, the burglary damage to structure or dwelling, which might be your count 2, Sheila. It's reverse on the sheet. Court will do $5,000, and I'll just put defendant has no bond hold. Okay. All right, so next one is going to be Roderick Jackson.
Here, main judge.
And Your
Here you
Honor,
go, Ms. Patrice.
this is also a change of charge. You had one of his co-defendants. It's a change of charge, strong arm robbery to robbery firearm. That was originally in this book, as you can see. And I provided the court with a copy of the original findings and a supplemental report. Judge Dennis Bailey found proof evident of presumption great for robbery with a firearm or deadly weapon, which is what we filed, and asked the court to adopt his finding on that charge and hold him no bond.
Okay, it originally said no firearm, so Judge Bailey, this is just a formality.
Yeah, he wrote it in.
Okay.
Charge 2 was upfiled from burglary occupied to burglary with assault or battery. That's why I provided the supplemental report. I'd be requesting the court make a finding of proof evident of presumption great on that count. And
So counts 1 and 2, you're asking for no bond, proof evident, presumption great.
Yes.
All right, what say you, defense? Mr. Reedy?
Yes, Judge, we would object to the court making a finding of proof evident presumption great. That's the highest standard we have in criminal law. What's been presented to the court today is an affidavit, which is written by the officer investigating the case. It appears the identification of Mr. Jackson was done pursuant to a show-up, which is a highly subjective, highly suspect form of doing an identification, without having more details as to what the alleged victim in the case was told before he was confronted with Mr. Jackson for purposes of making an identification. I would say that on the face of it, that identification is invalid. I would ask the court certainly not to make a finding of proof evident presumption great in this case, based on the weakness of the identification.
All right, when did Judge Bailey, it can't read the, looks like May 2nd or June 2nd?
This is June 2nd.
All right, so Mr. Jackson, I've reviewed the affidavits and other documents in your case, and I find a probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, you're going to be held without bond till further order of the court. This is without prejudice, or for you to set bond with your assigned division judge and request a hearing under State v. Arthur. And the court also adopts proof evident presumption great on count 1, the robbery with the firearm, by the magistrated judge Dennis Bailey on June 2nd, 2018. Okay, thank you, sir. Good luck to you. Next one is Sean Rich, please. Do you have these things for them? You didn't? Sean Rich.
How you doing?
Here, Judge.
Hi, sir. How are you? You have an aggravated battery with a deadly weapon. It's actually a change of charge from an aggravated battery. This is, they're adding with the deadly weapon or injury. Court does find probable cause. There was a $20,000 bond set. Correct?
Yes, Your Honor, and it's another technicality.
Is this a Judge Cohen case?
I don't believe so. Judge Canner set the bond, found probable cause. Your Honor, it's another technicality. He came through for an aggravated battery. He's before the court on an aggravated battery. Reviewing his record, I believe Judge Canner seriously considered his criminal history when setting the bond. He had trespasses on May 29th of this year, May 3rd of this year. Another trespass April 24th, April 11th, resisting without violence and trespass in January. Resisting without violence in November of last year. In 2017, he was convicted of domestic violence battery by strangulation and false imprisonment, and he violated his probation in that case.
Right, I don't have a probable cause affidavit in this case. All I have is the magistrate findings. Do you have it?
I can get the court a copy.
Yeah. And on the sheet it says CF 10A 2 times. I don't know if it matters, Sheila. Can you pull this up, please? CF. The arrest report. I don't need that. I have it. Michelle's printing it out. Okay, so the state's requesting a $20,000 bond.
Your Honor, I wasn't
No
done
vic-
that.
Huh?
I wasn't done giving his criminal history.
Oh, okay, I'm sorry, go ahead.
2016, grand theft auto, he violated probation. 2016, battery, resisting without violence. 2014, possession of cocaine. And just one moment, Your Honor.
Okay, while he's doing that, what do you have to say about the $20,000 bond?
Your Honor, I noticed that most of the offenses that were listed by the state were misdemeanor offenses. I know that Mr. Rich previously been in the system. However, he has had cases dismissed through alternative courts. He does currently live with his mom. She is a crossing guard in Pompano Beach. He attended school through the 11th grade. He doesn't reside with the alleged victim in this case. I'm sure the court would be imposing a no contact order, and that will not be any issue as they presently do not have any contact. But Mr. Rich presently cannot afford any bond. If he was able to make some sort of arrangement, it certainly wouldn't come close to the $20,000 that the state is requesting. So we would be asking the court to lower the bond significantly. Also, if the court would feel comfortable placing Mr. Rich on a pretrial release supervision to go along with the reduced bond, that's what we were requesting.
And Judge, I would want to advise the court, the cases he had dismissed, he had them dismissed for competency grounds, but the court should be aware those were charges of escape in 2016. Robbery.
What are you requesting, $20,000 bond?
I'm requesting, yes, the same bond that Judge Karen.
Okay, $20,000, no victim contact, direct or indirect, with the alleged victim, CJB. Is that the alleged victim's initials? That's what I have. Just want to make sure.
Yes.
Sir, there's no victim contact, direct or indirect. This is without prejudice for you to go before your division judge and ask them to look at the bond, okay? Thank you, sir. Good luck to you.
Thanks, Your
Save that for me. Next one is Michael I. Fox.
He is downtown, Judge.
What do you mean downtown?
He's in his division courtroom.
Okay. All right, let's just reset him for tomorrow.
Your Honor,
Yes?
I'd ask that he be reset for this afternoon. The reason being is he's going to be entitled to an ROI. I believe I provided the court with.
All right, where is he now? Do we know which judge?
I can check. I believe he's probably in front of Judge Usan, maybe on this case, but I'll check.
Okay, here you go, madam. Thank you.
Yes, he was arraigned this morning by Judge Usan.
Okay, Jonathan Marius. Save for later on. Pardon?
We're resetting for the afternoon. False.
Oh, he's here.
No, false.
No, he's Mr. Marius.
Oh,
Fox.
Mr. Marius, okay.
Okay. Okay, Mr. Marius, you have robbery with the firearm, burglary with assault or battery. These are two change of charges.
And Your Honor, this is the third co-defendant. You've heard the first two today.
Okay.
Again, Judge Bailey found proof evidence of presumption grade for robbery with a firearm or deadly weapon at his first appearance. We upfiled the burglary with assault or battery. I provided the same supplemental report and requesting the finding of proof evidence or presumption grade on count 2 based on that report.
I'd make the same arguments I just made from Mr. Jackson, Your Honor, that there is no proof evident presumption grade here. The identification of Mr. Marius Mr. Jackson and Mr. Downing were all conducted by show-ups, an inherently unreliable form of identification. And I would ask the court to find probable cause, I understand, until it can be attacked with the opportunity to cross-examine the witness. But certainly not proof evident presumption great. I'd ask you to set a bond for Mr. Marius. Mr. Marius, do not discuss the facts of the case.
No bond on 1 and 2?
That's what I'd be requesting, Your Honor.
Okay, and Judge Bailey was 6-2?
Yes, I believe so, Judge, yes.
Okay. All right, so Mr. Marius, I'm going to hold you no bond. I'm going to find proof evident presumption great. And I'm going to adopt Judge Dennis Bailey, who was a magistrate judge on June 2nd, 2018. This is without prejudice, sir, for you to file a motion, actually your attorney to file a motion with your assigned division judge and request a hearing under State v. Arthur. Thank you, sir. Good luck to you. 1 and 2, no bond. Thank you.
Appreciate it.
You're welcome. Wendy Pierre Luis.
Also downtown.
Okay, that's another one we need. These are 2 court orders for, let's see.
He was, yeah, and you only have to consider one of them, Your Honor, the one signed by Judge Tim Bailey, but his bond was actually revoked on this case before he...
From the ag assault?
Yes, when it was an aggravated assault, his bonds were revoked by Judge Tim Bailey.
Okay.
So, I'd ask that this be reset for tomorrow. I don't know if Mr. Reedy has an objection.
Okay, let's reset it for 7/19. Then we have Ronald McKenzie Robillard.
Conti, Your Honor. He's in courtroom 7750.
Okay, would want to reset it for tomorrow?
Yeah, that's fine.
All right, Robillard, we're going to reset for tomorrow. Who's he?
Why is William Rodriguez on?
William Rodriguez.
He was downtown this morning also for arraignment.
All right, let's reset him for tomorrow in the morning. All right, State, I'm going to give these back to you. Did we do Lamont Dixon? No, that's this afternoon. That's a second look. No AMs tomorrow. The ones I just gave you? I have no idea. Let me see. Are these the ones that you called up on? Julio Ramos and Terrence Dagrin. When did we reset them for?
Tomorrow morning.
Tomorrow morning. Thank you. Okay, we'll see you back at 1. Thank you, Mr. Vargas.
Thank you, Your Honor.
Thank you, Deputy.